All right. Go.
All right. Welcome back to part 2 of the episode on disciplinary policy from major misconducts to class 1 and class 2 misconducts and how they affect long-term prisoners who have been incarcerated more than 20 years. Um, and by the way, this is Prison Talk with Jamie Mead and
Emma Charleston. But you figured that out already, I'm sure.
and I did since our last phone call, I did ask a couple guys if they remembered when the policy was enacted or put into place, and they all said about 2010. So I might have been wrong with the 2007, but the point is, it does have a serious effect on those of us that have been incarcerated for a long period of time.
Yeah.
So regardless of the date it was put in place, the point
remains
is a valid. It's a very valid issue.
Do you think before you get into it, do you think this has obviously been a thing since it was put into place? So do you think everyone that's gone for parole or put commutations in since 2010, do you think that everyone who has done so may have actually been inadvertently thwarted by this change and it not being known?
Yes, that is a possibility. That is a possibility, and that's the possibility that we're raising, that I'm raising here on this podcast, because if I file a commutation, well, let's go to lifers. First degree lifers and second degree lifers are seen by the parole board on what is called a lifer review every 5 years.
Yeah.
And they will send down our names and they will ask the prison counselors to do what is called a lifer review report. And that is also called a parole eligibility report for those who are not lifers.
Yeah.
And when they write this report, they list on there the number. The sentence says how many misconducts, major misconducts / class 1s have the prisoner been issued since incarceration.
Yeah.
So if you have major misconducts, they list that total number.
Yeah.
But the key is / class 1.
Yeah.
So they are lumping, they don't distinguish what were major misconducts, or they just put a number there.
Yeah.
So that number represents how many times you've been to segregation in the eyes of a new parole board.
So that would suggest, though, Jamie, would it not, that a class 1, there is what you're saying is there is a difference between a major misconduct and a class 1, or there's not?
Yes, there on some major misconducts had 2 parts to it, which was only distinguishable on the misconduct report itself.
Okay.
And that was whether it was a bondable or non-bondable.
Okay, yeah.
Class 1s are all non-bondable. There is no distinguishment.
Yeah, okay.
It is clearly non-bondable. There is no ifs, ands, buts about it. So that is a concern, because a new parole board member that has just been on there for the last 5 years
may not be aware about that.
Yeah, they don't know. So they're only seeing that they don't even know if it's a major misconduct they're talking about, or if it's all class 1s. And so that's a big concern. So he may make the decision, I don't want to interview this guy who's serving life because he has 25 major misconducts.
Yeah. Yeah, well, how would you find out if that was a thing, and what would you do about that? Is there something you can do about that?
Well, the original intent that what I read from Richard Stapleton's article was when he drafted this policy, because he worked with the hearings division of the Michigan Department of Corrections, hearing and policy division. When he drafted this policy, he had the intent that major misconducts would eventually be distinguished, which would be class 1s or class 2s eventually, so people wouldn't be held accountable for all major misconducts being looked at as class 1.
Yeah.
But this never happened. He's no longer with the department.
Yeah.
And we have a new parole board that
doesn't know about
and one thing with the Michigan Department of Corrections, the Michigan Parole Board, they're on an island of their own. Yeah. They are accountable to no one.
Yeah.
They could actually tell you in a parole board hearing that they don't like you. They'll never let you out just because they don't like your personality. And there's nothing you can do. You could sue them.
Yeah.
But because we're not allowed to be represented by an attorney at a parole board hearing. Michigan created a statute that does not even allow an attorney to represent a prisoner at a parole board hearing.
What was the logic? What was the logic behind that?
Because attorneys are considered officers of the court.
Yeah.
And being officers of the court, they are credible. So if an attorney went in to court and said, I was present and I'm testifying under oath that the parole board member just totally misrepresented the facts, totally lied to my client, and totally told him that he's not going to do anything because he don't like his character.
Yeah.
The attorney would be listened to.
Yeah.
But since we have that, but without that, now the parole board can do
as it wishes. But my point in that question was, what was Michigan's logical explanation for that? Did you say it was a statute? Because I'm sure they didn't say. But I'm sure they didn't say that.
The parole board does not follow policy. So it was a protection of the parole board so they can grant or deny parole at any time without any consequences.
Yeah. I'm not satisfied with that answer. I'm gonna have to Google and find out. Because surely they can't get away with passing a statute like that if they don't have a rational explanation.
Michigan passed a statute, actually, doesn't it forbids a prisoner from appealing in the court a parole board decision.
Why?
We can't even appeal, but the victim or victim's family can ask the prosecutor to appeal to overturn a grant of a parole.
Yeah.
So they give a right to the victim's family or victim, but they take away the right to appeal to a prisoner.
Yeah. Well, that's a tough one because half of me sort of says, oh well, but I do know what you're saying there. But what's gonna, like, surely even if you appeal a negative decision on a parole, then they're not going to necessarily say, oh, oops, we're wrong, out you go. Anyway, are they?
Yeah.
I think that's ridiculous. Right, stay on track.
It's just the way Michigan operates. But I guess that's why the Sentencing Project, that's why organizations have come into Michigan now and labeled Michigan one of the worst states in the country for keeping prisoners in prison.
I have actually
because it's been they're dubbed the worst state, longest serving prisoners in the country. We have I think it's 1/3 of our prison population, 1 out of 7 or 1 out of 6 are serving life sentences. And majority of the prisoners that have these long sentences that's been locked up for over 20 years or 10 years were under the age of 25 when they committed their crime. So there's, they're looking at Michigan as a very, complicated state, one of harsh punishment with no remorse or second chances or
Would you call it very conservative, or is that more draconian?
It's draconian. I would say it's more draconian. It's that same mentality from back in the 70s and 60s and 80s, to lock up, throw away the key. Let's give them nothing. They're the worst of the worst. Bread and water through the door type of mentality. And while the rest of the world has moved in a different direction on prisons, making it more humane, rehabilitation, education as the focus, Michigan has remained in the category of, let's just give them life, or we'll give them 100 years to serve. we don't have to worry about them.
Well, because Michigan doesn't have the death penalty, like, as we know it.
They don't have.
But by the sounds of things, if they did, they'd be handing it out left, right, and center.
Well, they have life without parole, which is actually an alternative death sentence.
Yeah.
It's death by incarceration.
Yeah.
Because the likelihood of someone getting out of prison on a life without parole sentence is extremely rare in Michigan.
Is it rare across the country, or is it incredibly? Is it rare across the country?
No.
No.
It's rare. Many states, it's rare to get life without parole. Life without parole is an alternative to an actual death penalty sentence.
Yeah.
If the jury don't want to issue a death penalty, they, issue life without parole.
Yeah.
But Michigan uses it as, there's more people are convicted of first-degree felony murder sentenced to life without parole than majority of states around the country.
Yeah.
Even the states that don't have death penalties, their life without parole is used sparingly.
Yeah.
It's for the worst of the worst.
Yes.
Michigan will put a first-time offender in jail for that term of life without question. They don't look at, he's been to prison 4 times, or he's never been to prison. This is his first offense, and he was only 19 years old. They don't care. Yeah. They don't care whether you were the actual perpetrator or you were an aider and abetter. And in my situation, I was the aider and abetter. I was 19. My co-defendant was 18. Yeah. And he ended up with 12 years for committing the crime, and I ended up with life without parole for assisting him. Yeah. So if
you have 1 minute remaining.
Anyone thinks that's logical, then, maybe people should look at...
Maybe we should go back to school. Well, that's not logical. I mean, if he had received life without parole as well, I don't think anyone would even bat an eyelid, though, to be fair. If he and you both received, because that was the whole point of the mandatory minimums stuff anyway, wasn't it?
Yes.
Yeah.
Yes.
Yeah.
You both are responsible equally.
Yeah.
But there was no equity in that sentence.
No.
But I do want to keep this episode to 2 parts.
All right.
So you think we finished it? We accomplished our goal without getting off track too far?
Probably not. Probably
All
not.
right.
You're talking to me, and we always get off track when you're talking to me.
All right. But we thank you for joining us during this episode of Prison Talk, and we hope you join us again for the next one. Bye-bye.
Bye.